The COVID-19 pandemic has affected all small businesses in the U.S. Virgin Islands, but there is help to move your business forward. The Virgin Islands Small Business Development Center is available to assist entrepreneurs and small businesses. The VISBDC is the territory's #1 resource for small businesses and is sustained by the University of the Virgin Islands and the U.S. Small Business Administration. The VISBDC is nationally accredited and provides one-on-one advising, business education training, and technical assistance at no cost. Attend workshops by experts from both the public and private sectors. From idea generation to exit strategies, the staff at the VISBDC are ready to assist you. So don't wait. Call, email, or visit them on the web at www.visbdc.org and Facebook, or simply download their mobile app on the Apple or Google Play Store. Just search VISBDC. Discover how they can help your business grow and succeed.
Good morning, everyone, and welcome to the U.S. Patent and Trademarks Office USVI webinar series. We've brought the U.S. Patent and Trademark Office to teach, clarify, and connect you to the resources available for your USVI small business to grow and succeed. Now, let me just get in to tell you guys a few housekeeping rules. So just a friendly reminder to put your questions in the chat, and they can be addressed by the presenter directly in the chat or later during our question and answer segment. A copy of this presentation will be attached in the email sent after the live webinar, and we ask that you fill out a brief survey that lets us know how we are doing. So I'll let today's presenter introduce herself. We have none other than Ms. Elizabeth Doherty, and she's the Eastern Regional Outreach Director. So without further ado, she's going to go ahead and share her screen, and she's going to formally introduce herself to the audience. The floor is yours.
Good morning, and thank you, Sharika, for that kind and generous introduction. It is such a pleasure to be here today with you and your audience. My name is Elizabeth Doherty, as Sharika mentioned, and I am the Eastern Regional Outreach Director, which is really just a very long way of saying that my team and I help people. And we help people primarily on the East Coast, stakeholders engaging with the U.S. Patent and Trademark Office, using their intellectual properties to start and build and grow a business. And that's going to be our conversation today. And it's a pleasure to be in this collaboration with the SBDC of the Virgin Islands. Our focus today is going to be talking about some of the wonderful resources that are available to you through the U.S. Patent and Trademark Office. So I don't want to delay. We're going to get right into the content, but please feel free to ask questions throughout today's conversation. And of course, we will provide the slides to you for your use after today's event. Again, it's a pleasure to be here, and we're going to jump right into the content. So I'm going to share my screen. Very good. As you know, today we are here for the conversation about USPTO resources for inventors, innovators, and entrepreneurs. Not knowing where each one of you is at in your innovation journey, I'm hopeful that some of the tools we're going to talk about today are helpful to you as you begin to think about starting or building or growing a business. For those of you who may have attended our previous engagement with the SBDC of the U.S. Virgin Islands, we talked a little bit about what is, in fact, the U.S. Patent and Trademark Office. We are America's innovation agency, and we help to support fostering innovation and economic growth, and we do that by creating reliable, predictable, and high-quality intellectual property tools for use by individuals who are seeking to protect their creativity. We are one of America's oldest government agencies, beginning our work in 1790 with the issuance of the first U.S. patent. We are, in fact, written into the U.S. Constitution, and you'll see how and why. Why is this conversation today so very, very important? It's important because intellectual property is a cornerstone of creating a successful business. Unfortunately, oftentimes, though, it is a rainy day project. It's something that people get to when they have more time or more money, or perhaps a little less fear of what is that thing called intellectual property. We recognize as the U.S. Intellectual Property Agency, America's Innovation Agency, the USPTO, that people are not instructed about what the role and importance of an intellectual property is frequently enough. It's generally not part of our educational systems. It's not something we talk about, yet it is, again, the cornerstone of business. And why is that? Because intellectual property, whether a patent, a trademark, a copyright, or a trade secret, it can form one of the firm foundations of your business. It is something which makes your business attractive to investors and buyers. It can deter infringement lawsuits by putting people on notice that this is your creative property and that they need to come to you to request to license it, to purchase it, to use it with your permission. It can also increase leveraging power. Again, the power of the business when interacting with others in the industry. It's a property right bottom line that can add value to the company's assets. For any of us who have ever watched that television show called Shark Tank, the sharks invariably always ask someone who is coming to them to invest in their business, have you protected your intellectual property? Just one anecdotal reflection of how intellectual property can be attractive to investors and buyers. Now, when we say intellectual property is global, there has to be a word of caution there. There is no one international system of protection for intellectual property. Intellectual property is what we call territorial, and intellectual property protects you within the country that issues you that right. So, very simply, a US patent protects you within the United States. A US trademark protects you within the United States. But there are intellectual property systems that cover the entirety of the globe, whether regional or country based intellectual property systems. So, as I said, as I alluded to, the role of intellectual property is as old as our country itself. The founding fathers of our country knew that in order for us to be a strong and industrialized nation, we were going to need to support the rights of authors and inventors for a limited period of time, but to allow them to protect and to benefit from their creative property. So, Article 1, Section 8, Clause 8 is actually the intellectual property clause of the Constitution, calling out patents and copyrights. Now, trademarks are also within the US Constitution, but they're found within what we call the Commerce Clause. But again, it's so foundational to the growth of industry in our nation, the protection of intellectual property. I know today we're talking about resources, but in order to talk about those resources, I want to again reaffirm and lay that foundation of what is intellectual property. Well, there are four basic types when we talk about intellectual property. Generally, we're talking about either patents, trademarks, copyrights, or trade secrets. And just to touch on each one of those very quickly, let's keep in mind they each protect something very different for a very different duration, but yet they may all play together, so to speak, in creating an intellectual property portfolio for your company. Patents issued by the US Patent and Trademark Office protect what we think of as inventions, whether it's a new mousetrap, a new toothbrush, or a new cellular communication device. Trademarks issued by the US Patent and Trademark Office identify the origin of goods and services. Now, while not every company is creating something that is protectable by a patent, nearly every company, if not every company, probably has something protectable by a trademark because you want individuals to purchase your goods or services and you want them to know that they come from you, the creative mind behind those goods or services. Copyrights are protected by the US Copyright Office, which is a part of the Library of Congress. Copyrights protect a wide array of things, creative expressions stored in a tangible form, things such as works of art, things such as photographs, written publications, books, poems, music, architectural works. Many, many things are protected by copyrights. And then last but not least, there's trade secrets. Trade secrets are protected generally by the Uniform Trade Secret Act or oftentimes by contract law. Oftentimes, trade secrets are encompassed within a employee contract between an employer and the employee that employee will work to protect the secrets within that business. Trade secrets, like copyrights, can protect uh, a wide array of things, any information, in fact, that is valuable and can be kept confidential for that business. One thing that should also be kept in mind with these four different types of intellectual property, again, which can play together in an IP portfolio, is not only do they protect four very different things, they exist for four very different durations. Patents, for utility patents and plant patents, are good for 20 years from the first filing, the earliest filing. Design patents are good for 15 years from the date of issuance. And that is those are three very different types of patents: utility patents, plant patents, and design patents. Trademarks, uniquely, are incredibly valuable because they can last forever as long as the mark is continually used in commerce and the mark is renewed with the US Patent and Trademark Office every 10 years. Copyrights also have an extensive duration in that they are good for the life of the creator plus 70 years, so an incredibly long duration. Trade secrets, like trademarks, can last forever as long as the information continues to be valuable to the business and maintained confidentially, which requires that a business take steps to maintain that confidentiality. So, what is a patent? Let's just touch on these very briefly because, again, we want to jump into those resources that we're here to focus on today. A patent is the right to exclude others from making, using, selling, offering for sale, or importing the claimed invention. Now, inventions can be devices, they can be methods, they can be methods of creation, methods of production, they can be compositions, they can be business methods, they can be plants. So there's a wide array of things that can be patented. As I said, they are for a limited term, 20 years from the date of earliest filing or 15 years from the date of issuance for a design patent. And as I said earlier, they are a territorial form of intellectual property, providing protection only within the US. There is currently no worldwide US patent, no worldwide patents. So what is a trademark? As I've suggested, it is an indicator of the source of goods or services. And trademarks serve two very important purposes, one of which is for the consumer, one of which is for the business owner. For consumers, it allows us to identify the source or producer of different products and services, and it helps inform our buying decisions. We know what products we like and we want to find them time and time again. So by using that indicator, whether it's a sound or a scent or a word or an image, these things allow us to go back and find those goods and services again, whether it's our favorite type of cereal or whether it's our favorite type of tennis shoe. Additionally, trademarks are valuable for owners because they infuse the owners with that opportunity to provide goods and services of consistent quality to build goodwill in their brand. So, really, it is a two-way street as to why trademarks are important for a business. It's important both for the business owner that their marks, their products are sought and that they are identifiable, but it's also a benefit to us, the consumer, so that we get consistently high quality goods because those sellers, those producers of those goods and services want us to come back each and every time. So a copyright, again, protects an original work of authorship, including a wide array of things: literary, dramatic, musical, artistic, and other works in a fixed and tangible medium. So say, for example, if you sat down and wrote a poem this morning, that would be something that is copyrightable, assuming that you have placed it in a fixed and tangible medium, whether that's on your computer or you've handwritten it on a piece of paper. The Library of Congress administers registration, while the USPTO does advise the executive branch. That we do advise the administration on intellectual property issues, including copyright. Now, when we say the C with the circle, which is an indicator of copyright, can be used without registration, that is because copyrights are what we call self-authenticating, meaning by merely placing that original work of authorship in a fixed and tangible medium, you have a copyright. You don't have to apply to the US Copyright Office. However, We would encourage you to do so if it is something that you wish to protect and enforce against others. In order to avail yourself of all of the rights of a federally registered copyright, you need to go the step of registering with the US Copyright Office. And in that respect, trademarks are very, very similar. There are common law trademarks. You have a common law trademark by using your mark in commerce, and that is without registering it with the US Patent and Trademark Office. However, if you want to avail yourself of the benefits of a federally registered trademark protecting you across the nation in interstate commerce, we would strongly encourage you to register your copyright with the US Patent and Trademark Office. And last but not least, returning back to the concept of a trade secret, any information, formulas, patterns, compilations, programs, devices, methods, techniques, or processes. Oftentimes, there are things such as recipes. They say that the recipe for Coca-Cola is held in a vault in Atlanta, where the Coca-Cola headquarters is. This information derives economic value from not being generally known or ascertainable. States have some sort of trade secret protection, but again, most of these laws are based on the Uniform Trade Secret Act. So let's get into the meat of what we came to talk about today, and that is resources available to you as inventors, innovators, and entrepreneurs, resources available to you through the US Patent and Trademark Office. And many of these resources, I'm going to tip my hat here, many of these resources are my favorite four-letter word, FREE, free. So I want to be sure and call that out right in advance. Now, for those of you who have not visited us at our website, I would strongly encourage you to do so. This should be your starting place with the US Patent and Trademark Office. While we love to engage with you one-on-one by phone or email or in person, I always strongly encourage people to get their feet wet with intellectual property by visiting our website. Now, when you look at our website, and this is just a screenshot of the front cover of our website, this image here, the Artificial Intelligence for All, is what we call our journey of innovation. This is a monthly story that changes each and every month to highlight remarkable inventors, innovators, and entrepreneurs who are doing interesting things across our nation. These help to highlight inventors and their journeys through the innovation ecosystem. We can all learn a little something from someone who's gone the road before us. When you look at the top toolbar of our website, you see patents, trademarks, IP policy, and learning and resources. For those of you who are visiting us for the very first time, I would encourage you to start with that learning and resources pull down tab. In my mind, that's where the good stuff is. That's where the stuff that's really going to help you to enhance your learning and appreciation of the role and importance of intellectual property is. Now, of course, if you're new to intellectual property, you can find a quick pull down list there on the right side of our website that leads you to patent basics, trademark basics, inventor and entrepreneur resources, accessing our free services, the USPTO in your region, and many, many more things. But again, looking at this homepage, I would encourage you to start with the Learning and Resources pull down tab. Now, of course, if any of you are looking for a job opportunity and are interested in working with the federal government, interested in working with the US Patent and Trademark Office, don't hesitate to reach out to us through the jobs icon there at the very top of our webpage. And then, of course, Contact Us has a lot of information about how to engage with the office. But let's move on to our next slide. Finding help in your area. So my team and I, the Eastern Regional Outreach Office, are located uh, physically at our Alexandria headquarters, which is in Alexandria, Virginia, right outside of the beautiful Washington, D.C. We do also have regional offices that are located in Detroit, Denver, Dallas, and San Jose. The regional offices were stood up as a result of the 2011 America Invents Act. The American Invents Act directed us, Congress directed the US Patent and Trademark Office to get in the game of having regional offices. Many, many other government agencies do and have for quite some time, but this was very new to us, having only ever been in the Washington, D.C. vicinity. Well, with that said, we are also in the process right now of standing up a new regional office. We haven't identified the location yet, but in December of last year, December of 2022, Congress, through again legislation, directed the US Patent and Trademark Office to stand up a Southeast regional office. So we're underway with that adventure right now. So there's going to be an office coming much closer to the US Virgin Islands in the not too distant future. These regional offices have the opportunity, and my office as well, there at the Alexandria headquarters, have the opportunity to welcome in visitors. We also do a lot of very robust in person and hybrid programming across our regions. So as you can see, we also provide a lot of help with respect to having individuals come in to learn how to search for patents and trademarks, connecting with inventor and entrepreneur organizations in our areas, providing free and reduced cost legal assistance, which we're going to talk a lot more about. Um, and again, we are located across the nation supporting inventors, innovators, and entrepreneurs. For those of you, again, who are just getting your feet wet in the concept of intellectual property, you may be thinking to yourself, okay, Elizabeth, I've now heard that there are 4 types: patents, trademarks, copyrights, and trade secrets. How do I know which type of intellectual property is best for me in the endeavor that I'm creating? Whether it's opening up a new nail salon or bringing a product to the marketplace, how do I know what kind of intellectual property I'm creating? Well, we've got a new tool to help you decipher that, and it's called the IP identifier tool. By accessing our IP identifier tool, which is on our website, through taking a series of 6 questions, answering 6 questions, you will get a readout on what types of intellectual property you might be creating in your business and what you should familiarize yourself with as you begin to build your individualized intellectual property portfolio. Again, it doesn't matter whether you're opening a new dry cleaning business or bringing a new bicycle to the commercial space. Uh, the IP identifier tool can help you identify whether you're creating something protectable by a patent, by a trademark, by a copyright, or a trade secret, or perhaps all of the above. Our free services finder. The free services finder, which you can find right off that USPTO.gov homepage, is kind of a one-stop shop for many of our services. You'll see when you look at our free services finder, it breaks down the information into patents, trademarks, and information that would be of interest to attorneys and business advisors. Now, that all resources just culls those all into one location, but this identifies many of the programs that are available to you through the US Patent and Trademark Office. And again, it creates a one-stop shop on our website. Now, these individual items can all be found at other places on our website as well, but by accessing them through the free services finder, you put them all in one place so they're a little bit easier to find. Sometimes I like to say our website is so rich with resources that they're hard to find because there's so many of them, but they're on different respective web pages within our website. So that can be frustrating sometimes, even to myself. For those of you who are inventors and entrepreneurs, and I hope that's many of you in our audience today, we have put together some resources really directed and spot on for you. And these are provided again in kind of a one-stop shop fashion, but in a chronological fashion. And I really love this approach, and I find it very beneficial for people who are at some part of the process and need to know what they may have already overlooked or how to get started, or taking where they are at and knowing how to further proceed. So as you can see, this hub of resources starts with getting started. What are the types of IP protection? Using our IP identifier tool, some of our free trainings to help you get started. But then it also moves you through the process. What do you need to know before you apply? How can you get help to apply? How do you apply for IP rights? What is the process? What is the application process? How does one go about applying for a patent or a trademark? You know, I recently had a conversation with a inventor who was just getting started, and they asked me where the patent application form was. And I had to work with this individual to identify that applying for a patent is not quite like applying for a job. There's not an application submission form where you just fill in some blanks to apply for your patent. Patents require a certain form and format that is set forth by the patent laws and patent rules that govern US patent practice. But it was a great question. And I could see where this individual was coming from because oftentimes when we apply for things, whether it's a job or a driver's license, there is a form you fill out. So it was a really great question. Again, following through this information for inventors and entrepreneurs, you can see information for after you apply. Keeping in mind that once you receive your IP rights, whether that's a patent, trademark, copyright, you are the one who then the responsibility falls to enforce your rights. So, how to appeal or fix an issue? Because sometimes there are challenges after one receives your intellectual property rights. Entrepreneur resources. Here are some things to help you as you take that invention or as you take that trademark brand to the marketplace. How can you do so successfully? And then, of course, protecting yourself. I always want to call this out because there are a number of patent scams and trademark scams going on across our globe. Individuals who are only too happy to take your hard earned money and not turn it towards something that is important or relevant to your intellectual property. As my mother used to always say, if things sound too good to be true, they probably are. So we want to always alert individuals to the present patent and trademark scams so that you don't lose your money to an unreputable source. Since we're talking about entrepreneurship, I want to be sure to call to your attention a remarkable initiative that was stood up under our current director. Our current director, her name is Kathy Vidal. She is a patent practitioner by heart and has done wonderful things in our innovation ecosystem, including standing up a monthly series for women entrepreneurs. Now, in saying women entrepreneurs, we certainly open the doors to each and every individual who wants to participate. These monthly workshops are on a wide variety of topics pertinent to entrepreneurship. And in fact, you are so very lucky that there is one taking place today. You can find it on our website. It is taking place today directly after this session. So if you've got some time, go to our website, sign up for. I'm assuming if you're in the Virgin Islands, you're going to sign up virtually. But if you happen to be tuning in from California and want to be there in person, you're welcome to do so as well. Today's topic for entrepreneurs is funding your startup. And we've got a great panel of speakers to provide some expertise and information on how to fund your startup. So, again, that's our women's entrepreneurship. You can find today and all of the upcoming women's entrepreneurship programs on our website if you go to our events page where you'll be able to sign up for all of our free programming. So, again, just calling out the Women's Entrepreneurship or WE program has a monthly webinar, which is offered in a hybrid fashion in person and virtually, and covers a wide variety of topics. Again, whether it's protecting your intellectual property, mentorship, securing funding. Similar to our resources for inventors and entrepreneurs, we do also have a landing page specifically for startups. And while this takes some of the information from those previous pages, it also goes that little bit further. It starts with protecting your intellectual property rights because remember, as I said, intellectual property can be a part, should be a part of that firm foundation of your small business. Planning for success, doing your homework, knowing what to do as you begin to build your startup. Finding funding. Again, the topic for today's WE program, how to fund your startup, and then engaging with experts. So this page is also incredibly valuable in leading you to other resources as you start and build and grow a business. When filing for a patent application, we strongly encourage our applicants to use the assistance of a patent attorney or a patent agent. However, we know for some individuals that's not the road that they take. That's not the path. Because one, they either want to do it themselves, which is perfectly fine. There's no requirement by law or rule that you use a patent attorney or a patent agent, or perhaps you cannot afford one. Now, we are going to talk here very, very briefly in a moment about the patent pro bono program and law school clinic program. But before we get to that, if you are an applicant applying for a patent and you want to go the road alone, and a certain percentage of our population does so and does so very successfully, we do have additional resources available to you, and that's through our Pro Se Assistance Program. The Pro Se Assistance Program can help applicants who are going the road without an attorney or agent by providing a little additional handholding. They're there to answer your questions. They're there to help provide assistance and information each step of the way as you go through the patent application process. But again, with that said, we do strongly encourage the use of a patent attorney or patent agent just because of the complexity of applying for a patent. Inherently, it is a complex process with a lot of laws and rules that govern the process. So we want you to get it right and to receive your US patent. For those of you who are needing help with patents or trademarks, we have a wonderful assistance center in both respects. For both patents and trademarks, these assistance centers are staffed 8:30 to 8 every Monday through Friday and are staffed by remarkable people who are eager to answer your question. They take questions both by phone and by email. And many of these individuals staffing the assistance centers are 30 and 40-year career veterans of the US Patent and Trademark Office. They are individuals who have heard it all and again are eager to take your questions and are going to help you walk through that process. So never be afraid to call our Inventor Assistance Center or our Trademark Assistance Center because these individuals are there to help you and they enjoy getting your questions and are eager to help. So never hesitate, no matter where you're at in the process, either prior to filing, you've already filed and you've got a question, or maybe you've already received your patent or trademark and still have a question. Never hesitate to reach back out. There's no charge for reaching out to either of our assistance centers. So now we are at the long awaited information about our free legal assistance programs. So you may recall when I talked about our regional offices located in Detroit, Denver, Dallas, and San Jose, that was a result of the 2011 America Invents Act. That same act, the 2011 America Invents Act, also urged the US Patent and Trademark Office to work with legal associations across the nation to stand up a nationwide program that would provide free or reduced cost legal assistance to under-resourced inventors and small businesses. And we did just that. And we've done it very, very successfully. We, in fact, have covered the nation in either state or regional patent pro bono programs to assist inventors who are under-resourced to seek patent protection. You can find by visiting us, by visiting our website, you can find the Patent Pro Bono program that covers the area in which either you live or your endeavor is taking place and apply to that specific Patent Pro Bono program. Now, there is an application and each Patent Pro Bono program has a different application. And as part of that application, they're going to ask you a few things. They are going to ask that you have more than a mere idea. Now, when you say, well, Elizabeth, what does that mean? More than a mere idea? Does that mean I have to have a prototype of my invention? And the answer is no. But you have to have an invention that you are in such possession of that you can file a patent application. You have to have such possession of that invention that you can describe it with such specificity that others can make and use your invention. I'll give you a quick example. I have an idea. My idea is I'd like to build a time machine because I'd love to go back in time and meet famous people like Abraham Lincoln and Harriet Tubman. Now, do I have an invention? Sadly, no, I have an idea. I don't know the first thing about creating a time machine to travel through time and meet remarkable people. So I would not be able to take advantage of the assistance of one of these patent pro bono programs because you have to have more than a mere idea. You also have to have some skin in the game by either having filed your own provisional patent application or having taken an online course on our website showing that you know what you're getting yourself into. Because these free resources are limited, we want to make sure that those people who are taking advantage of them are in fact going to use this patent, if they receive one, to go on and build and grow a small business, to create jobs in the economy. So we don't want these to be for individuals who are just looking to hang a patent on the wall. So again, you have to have more than a mere idea. You have to have skin in the game. You have to be under a certain financial cap because again, these resources are available for financially under-resourced inventors and small businesses. With that said, in addition to the Patent Pro Bono program, which has these regional or state patent pro bono programs across the nation. We also have a large number of law schools who participate in what is called our Law School Clinic Certification Program. These programs provide patent or trademark, and sometimes both patent and trademark assistance to under-resourced inventors and small businesses in their communities through a great program that not only helps our law school students to become the next generation of IP practitioners by giving them some experience in working with clients such as yourself, but it also provides, again, enhanced and greater ability for us to help support under-resourced inventors and small businesses. You can find which law schools are participating by, again, visiting our website. If you look to the USPTO in your region, in your area, that's where you're going to find the patent pro bono program that's in your area and the law school clinics that are participating in your area. So again, go back to that map on our website, and that's where you'll find it. Additionally, we have patent and trademark resource centers. The Patent and Trademark Resource Centers is a network of over 80 libraries located nationwide in public libraries. Now, more often than not, these public libraries are at colleges or universities, but each one of these libraries has one or more librarian who is trained in patent and trademark searching. Now, you may be saying to yourself, why is that significant? There's no requirement that I do a patent or trademark search, is there? And the answer is no. You would be correct. However, you are strongly encouraged before you outlay a headache and heartache and financial outlay to conduct a patent or trademark search, uh, depending on which you are seeking, whether it's a patent for your invention or a trademark for the indicator of your goods and services, because maybe your idea is just so great, someone's already thought of it. So by conducting a patent or trademark search, you can determine what the landscape looks like in your field of endeavor. Find out, has anyone already invented that toothbrush that you've come up with, or invented something very, very similar, which might make it difficult for you to receive a US patent? It can help you to further refine your invention, and it can also help you to, again, better understand the landscape of the area in which you're inventing. Similarly, for trademarks, maybe that mark, whether it's a word mark, an image mark, or one of our non-traditional marks, scent, sound, color, you can find out if somebody else is already using that in your area of endeavor. Because remember, when applying for a trademark, you are applying for a trademark with respect to a certain class of goods. So whether you're planning on using your mark on apparel, hats and caps, or whether you're planning to use your mark in some other fashion on beverage services or again, a dry cleaning business. You are going to apply for your mark in a certain class of goods and services. So you're going to want to see who else is working in that area and what they are using as their mark, because you don't want to infringe upon somebody else's mark. And you also want to ensure that you have a strong mark. Reduce patent fees. I know I told you my favorite four-letter word is free. So let's talk a little bit about fees to the office. Now, I know oftentimes individuals do not seek intellectual property protection because it is an additional cost, whether it's seeking a patent, registering a trademark, registering a copyright, it does require fees. With that said, I will let you know that the US Patent and Trademark Office is the cheapest uh, intellectual property system in the world. Now, with that said, again, I know there are still fees involved. Trademark fees are relatively inexpensive, copyright fees, incredibly inexpensive. Patent fees are perhaps the most substantial fees that are charged by the US Patent and Trademark Office. And these are the fees that you pay for the US Patent and Trademark Office to examine and prosecute your patent application. Um, so when talking about patent fees, there are three different fee levels. One is for our large entity filers, what we think of as generally large business. Um, we also have our small entity filers. Those are individuals or small businesses of less than 500 employees or a nonprofit organization. So if you fit within those qualifications, you could be a small entity filer with the US Patent and Trademark Office. If you are a small entity filer, you pay fees reduced by 60%. So if you are a small entity filer, you certainly want to take advantage of that. Additionally, there's another fee level. There is our micro entity fee level. Now that is if you as an individual or your company meets the small entity requirement, you have filed no more than 4 previous applications, you have an income not greater than 3 times the median income, you are not assigning your rights to someone other than another micro entity or yourself, um, you can qualify to pay fees reduced by 80%. Now, I do want to caveat this in that if you are a micro entity and you want to take advantage of the micro entity discount, those fees reduced by 80%, in the instance of being a micro entity, you do have to file a certification statement. That certification statement is your way of saying to the office that, yes, I am entitled to paying these reduced fees. So if you think that you fall within this category, you want to be sure to file that certification statement as early as possible so that the fees you pay are reduced by 80%. So again, keep in mind, there are large entity filers, small entity filers, and micro entity filers. This is with respect to patents and patents only. Trademarks does not have a breakdown of those fees. While we're on the topic of fees, it might just be interesting to share with you that the US Patent and Trademark Office is an incredibly unique agency in that we are a fully fee funded agency. And what does that mean? We are we do our work entirely based on the fees paid by our applicants. We, in fact, receive no taxpayer dollars, and our fees are set on a cost recovery basis, which means that we do very extensive analysis on the time and duration that it takes to do each and every step of examining a patent, of examining a trademark registration application. So we know down to nearly the minute how long it takes us to do each step of our process, and we charge accordingly. Just kind of a little interesting point. Just thought I'd share. Um, let's talk about patent protection fast. On average, right now, if you are filing for a US utility application, it is taking approximately 14 to 18 months to receive a first communication from the US Patent and Trademark Office. And I say on average because it depends on the area in which you're filing. If you're filing in an area where there's a large amount of filing, things such as medical devices, video games, cellular communication devices, it might take longer. If you're filing in the area of mousetraps and toothbrushes, it might not take that long. And on average, it is taking over 2 years to receive a US patent. Now, sometimes our applicants find themselves in a position where they need an answer much quicker. So we have something that's called Track 1 Prioritized Examination. For an additional fee, and again, because it's a patent opportunity, there are micro entity, small entity, and large entity breakdowns of that fee. For Track 1, you can get expedited examination, meaning if you file the additional fee, we can pick your application up and process it much more quickly. Now, that also puts you on the hook to respond much more quickly because keep in mind, patent examination and patent prosecution is a back and forth process between you, the applicant, and the US Patent and Trademark Office. I'd be remiss if I didn't tell you about something that's very important to our agency, and that is our effort for inclusive innovation. As we like to say, we are competing against the rest of the world with 4 fingers in one hand tied behind our back if we don't get more diverse populations of individuals seeing themselves as able to participate in invention, innovation, and entrepreneurship. And that's diversity of all types, diversity of gender, ethnicity, geography. So we need to have all individuals as seeing themselves as able to bring forward any type of invention, innovation, and entrepreneurship. So we've done a lot of things as an agency and continue to stand up new initiatives and programs to encourage and incentivize and empower inclusive innovation. One of those, in fact, is our Council for Inclusive Innovation. This council is standing up a number of programs, including something I'm going to talk about here in just a second, our first-time filer expedited examination process. So for first-time filers, and maybe some of you in the audience who are contemplating filing a patent application can take advantage of this first-time filer expedited examination program. For those who are filing for the very, very first time, we are accepting up to 1,000 applications for people who would like to get a first office action response more quickly. Because we know sometimes it's getting that first office action response that helps you to take that next step, to know whether or not to continue to proceed. It's with that first time response from the office that you can get a feel, a flavor for where your invention is going, what the US Patent and Trademark Office, through its patent examining core, is able to tell you about the invention that you are seeking to protect. So, just to let you know that's out there, it is a petition process to participate, but it is a no fee petition process. So, what happens if you take advantage of this first time filer expedited pilot program? If you file the petition process and are accepted into this program, your application will be picked up out of turn from the backlog and taken more immediately. Now, when I say picked up and taken out of turn out of the backlog, let me tell you, each year for the last few years, we've been receiving over 650,000 patent applications each and every year. So that's what we call the backlog. When your application for patent comes in, it is added to that cadre of applications that's already undergoing examination, that are in the office and receiving attention from our US patent examiners. The application is afforded special status without you having to incur any special fee. So again, this is a free petition to participate in this pilot program if you are able to do so. Just some additional resources we have for you, some guides, things that you can find, and find these again throughout our webpage. These are some of the many web pages that are part of our website. I've got two final slides because I know we're coming to the end of our time together and I want to be sure and allow time for your questions. I would be remiss if I didn't draw attention to our events. Just as we're having this event today in collaboration with the SBDC of the US Virgin Islands, the US Patent and Trademark Office teaches classes every day of the week, Monday through Friday, on a wide variety of topics. And these classes are all free. I encourage you to attend as many of them as you would like on a wide variety of topics. And you can find this listing of USPTO events, including today's We Wednesday program, by visiting that Learning and Resources pull-down tab. Remember that tab I told you, that one that runs across the top of our toolbar? If you go to the Learning and Resources pull-down tab, you can find the Events tab, which will lead you to our calendar of events. You can also find the events from the homepage itself, but again, you can also find it from that Learning and Resources pull-down tab. I know there's many, many classes, but they're offered, just to highlight a couple of them for you. We do a trademark bootcamp series, which is remarkable. Learning about trademarks from soup to nuts. How does one file? How does one prosecute with your trademark examining attorney through the entirety of the process? What does that look like? We also have something called our Patent Pathway series. In the Path to a Patent series, you can learn about applying for a patent through all of the various steps of the process. We teach patent and trademark search classes. We teach protecting your intellectual property abroad. And I would especially be remiss if I didn't call out something that my team in the Eastern Regional Outreach Office does. We teach a 5-part Spanish language series. And in fact, it's going on this week. We teach a class in Spanish and then replicate that class in English. So today's class is Patent Basics. It is being taught in Spanish and then later this afternoon in English. And again, you can find those classes on our website as well. I encourage you to visit our USPTO events page, find out some of the great classes that are there. They're for inventors, entrepreneurs, parents, teachers, students. Again, a wide array of subject matter and a wide array of opportunities for learning. Last but not least, staying connected with the U.S. Patent and Trademark Office. You can sign up through our subscriptions to receive USPTO emails in your box. We have over 12 subscriptions on very specialized topics: patents, trademarks, copyrights, trade secrets, international intellectual property. You can sign up for these subscriptions, one or all of them, to receive information in your inbox. Now, I promise you, we won't sell your information. We won't spam you. We only will reach out and communicate with you, one, on the topic that you desire to be communicated with, but also when we have something significant to say. It's not something where we drop something in your box each and every day. It's where we have something significant that we want to bring your attention to. So again, those are our subscriptions, and we encourage you to sign up for as many of them as you would like. With that said, I want to alert you to our social media handles. We have a very active social media presence, so we hope that you will join us on social media. I'm also giving you the email address for my team in the Eastern Regional Outreach Office. Please do not hesitate to reach out if you have a question or need assistance. We are always happy to address that through email, but also happy to set up a virtual conversation, to set up a one-on-one meeting where we can discuss with you your intellectual property questions, issues, or challenges. With that, I am going to transition to some final slides for the SBDC. But again, if there are any questions, I am happy to take those too, because I know we still have just a handful of minutes left in our time.
Okay, so thank you so much, and I'll jump straight to the first question.
Sure,
Does the
please.
USPTO have pre-recorded education sessions that can be viewed at any time?
It's a great question. And in fact, we do. We have a YouTube channel, and I'll go back just a couple of slides. Oh, we don't have our YouTube channel listed here. I'm sorry, we do, the USPTO video. We do have a number of pre-recorded classes that are available, especially that trademark bootcamp series. We have something called our Trademark Information Network, which is a really good series for those of you interested in learning about trademarks. But we do have a wide array of information that is pre-recorded. I'll give you another great example. We just recently hosted our annual event called InventionCon, which is a 3-day program with a wealth of resources for inventors, innovators, and entrepreneurs. Uh, those sessions were conducted virtually and in person, and those will be posted here very shortly. So if you weren't able to tune in for InventionCon 2023, you'll soon be able to experience it on our USPTO video channel. The majority of classes that we teach oftentimes have a recorded portion as well. So you're welcome to visit a past event page to see if a recording has been posted, because sometimes we post those as well. But the USPTO video link is a great place to look for our recorded materials. Any additional questions?
I don't see any at the moment, but I'll take this
Okay.
time to point out that the VISBDC has so much more in store for the USVI small business community. You can visit our website at www.visbdc.org. Download the VISBDC app on your mobile device from the appropriate app store. Like and follow us on Facebook, Instagram, Twitter, Google Business, and you can definitely subscribe to the VISBDC YouTube channel for an on-demand webinar. So I don't see any questions formulated, which means you did an excellent job and everyone got what they
Fantastic.
needed. But in the interim, let me just give it a little more time and highlight a few upcoming events. So we want persons to know that we have on tomorrow, exactly, we have VI Apex, and they will be presenting on the 8A Business Development Program. That webinar is scheduled to begin at 11 a.m. And then next week, Wednesday at 11 a.m., the 31st, we'll be wrapping up this series, and we will be presenting on small business owners learning how to contract with the USPTO. On June 13th, we have USVI Marine Tourism Industry Entrepreneurship Readiness. That webinar will be starting at 11 a.m. On June 15th, we have SBA, and the local office will be presenting on surety bonds 101. We also have the business development webinar series, and the presentation on developing your business plan will be hosted on June 28th. And on June 29th, we have back again VI Apex, and they're going to be presenting on veteran contracting assistance programs. So we want persons to go ahead and register, continue to interact with us as we make these webinars available to you. After the live event, these webinars are converted into on-demand webinars. So all you have to do is go back to the VISBDC portal, put in your email address and login information, and you can watch at your leisure, in case you didn't know. So I don't see any more questions at this time. So I'll just take the opportunity to say thank you for attending. We're about to email you a copy of this presentation, in addition to a survey that lets us know how we're doing, so we can continue to provide these services to you at low or no cost. So on behalf of the entire VISBDC network, thank you so much, Director Darty with the USPTO, for coming today and giving us all of these important resources that USVI small businesses can benefit from. And to everyone participating in the audience, we hope that you have a productive rest of the day, and we look forward to seeing you at our upcoming events. Thank you so much.
Thank you, Sharika. It was a pleasure to be with you and your audience today. Best of luck and best of success to everyone in their innovation journey.
Bye.